binding effect of the award regarding the boundary between a colony of British Guyana and the United States of Venezuela on 3 October 1899, to which I shall refer as the 1899 award or the award. In its judgment of 18 December 2020, to which I shall refer as the 2020 judgment, the Court found that it has jurisdiction to entertain the application filed by Guyana insofar as it concerns the validity of the 1899 award and the related question of the definitive settlement of the land boundary dispute between Guyana and Venezuela. The Court also found that it did not have jurisdiction to entertain the claims of Guyana arising from events that occurred after the signature of the agreement to resolve the controversy between Venezuela and the United Kingdom of Great Britain and Northern Ireland over the frontier between Venezuela and British Guyana, signed at Geneva on 17 February 1966, to which I shall refer as the Geneva Agreement. I further recall that in its judgment of 6 April 2023, to which I shall refer as the 2023 judgment, the Court rejected Venezuela's preliminary objection concerning the exercise of the Court's jurisdiction and found that it could adjudicate upon the merits of Guyana's claims, insofar as they fall within the scope of the Court's jurisdiction as defined in the operative clause of the 2020 judgment. I finally recall that on 30 October 2023, Guyana filed a request for the indication of provisional measures referring to Article 41 of the statute and Articles 73 and 74 of the Rules of Court. In its request, Guyana states that on 23 October 2023, the government of Venezuela, through its National Electoral Council, published a list of 5 questions that it plans to put before the Venezuelan people in a consultative referendum on 3 December 2023. According to the applicant, the purpose of the questions is, I quote, to obtain responses that would support Venezuela's decision to abandon these proceedings and to resort instead to unilateral measures to resolve the controversy with Guyana by formally annexing and integrating into Venezuela all of the territory at issue in these proceedings, which comprises more than 2/3 of Guyana. End of quotation. In accordance with the usual practice, I shall not read the introductory paragraphs of the order, which set out the procedural history of the case. I shall also omit or summarize some other paragraphs. I shall accordingly begin the reading of the order at paragraph 13. The full text of the order will, of course, be available at the close of the sitting. The Court begins by recalling that it already set out in its 2 judgments in the present case the general background and context of the dispute between Guyana and Venezuela, which dates back to a series of events that took place during the second half of the 19th century, when Guyana was still a British colony known as British Guyana. At that time, the United Kingdom and Venezuela both claimed the territory located between the mouth of the Essequibo River on the east and the Orinoco River to the west. In 1897, an arbitral tribunal was established to settle the boundary between British Guyana and Venezuela. In its 1899 award, the arbitral tribunal granted the entire mouth of the Orinoco River and the land on either side to Venezuela. It granted to the United Kingdom, in respect of British Guyana, the land to the east extending to the Essequibo River. Between November 1990 and June 1904, a joint Anglo-Venezuelan commission demarcated the boundary established by the 1899 award. On 10 January 1905, after the boundary had been demarcated, the British and Venezuelan commissioners produced an official boundary map and signed an agreement accepting inter alia the coordinates of the points listed were correct. On 14 February 1962, Venezuela informed the Secretary General of the United Nations that it considered there to be a dispute between itself and the United Kingdom concerning the demarcation of the frontier between Venezuela and British Guyana. The government of the United Kingdom, for its part, rejected that contention, asserting that the question had been finally settled by the 1899 award. After various attempts to resolve the matter failed, the representatives of the United Kingdom, Venezuela, and British Guyana signed the Geneva Agreement on 17 February 1966. On 26 May 1966, Guyana, having obtained independence, became a party to that agreement. Attempts were made in the ensuing decades to resolve the dispute through different means of settlement envisaged in the Geneva Agreement, all of which failed, leading the Secretary General of the United Nations in January 2018 under the Geneva Agreement to choose the court as the means to resolve the dispute. Having recalled this general background, the court then turns to the requirements for the indication of provisional measures. With respect to the question of jurisdiction, the court observes that it may indicate provisional measures only if the provisions relied on by the applicant appear, at least prima facie, to afford a basis on which its jurisdiction could be founded. In the present case, the court has already found in its 2020 judgment that it has jurisdiction to entertain the application filed by Guyana on 29 March 2018, insofar as it concerns the validity of the 1899 award and the related question of the definitive settlement of the land boundary dispute between Guyana and Venezuela. The court further recalls that in its 2023 judgment, it found that it could adjudicate upon the merits of the claims of Guyana insofar as they fell within the scope of the operative clause of the 2020 judgment. The court then proceeds to consider the other requirements for the indication of provisional measures. The court recalls that its powers under Article 41 of the statute to indicate provisional measures has as its object the preservation of the respective rights claimed by the parties in a case, pending its decision on the merits thereof. It follows that the court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. Therefore, the court may ascertain this power only if it is satisfied that the rights ascertained by a party requesting provisional measures are at least plausible. At this stage of the proceedings, however, the court is not called upon to determine definitively whether the rights which Guyana seeks to protect exist. It need only decide whether the rights claimed by Guyana on the merits and for which it is seeking protection are plausible. Moreover, a link must exist between the rights whose protection is sought and the provisional measures being requested. The court observes that Guyana contends that it seeks the preservation and protection of its right to the territory awarded to it by the 1899 award, pending the court's determination of the validity of that award and to the integrity of its territory, or alternatively, its right to the settlement by the court of the land boundary between Guyana and Venezuela. The court recalls its finding in the 2020 judgment that a land boundary dispute exists between the parties. It further observes that the territory which forms the object of that dispute was awarded to British Guyana in the 1899 award. In light of the foregoing, the court considers that Guyana's right to sovereignty over the territory in question is plausible. The court then turns to a requirement of a link between the rights claimed by Guyana that the court has found to be plausible and the provisional measures requested. The court observes that one of the provisional measures requested by Guyana seeks to ensure that Venezuela does not, I quote, take any actions that are intended to prepare or allow for the exercise of sovereignty or de facto control over any territory that was awarded to British Guyana in the 1899 award, end of quotation. The court considers that this measure is aimed at protecting Guyana's right, which the court has found plausible. The court concludes, therefore, that a link exists between the rights claimed by Guyana that the court has found to be plausible and the aforementioned requested provisional measure. The court next notes that, pursuant to Article 41 of its statute, it has the power to indicate provisional measures when irreparable prejudice could be caused to the rights which are subject of judicial proceedings, or when the alleged disregard of such rights may entail irreparable consequences. However, the power of the court to indicate provisional measures will be exercised only if there is urgency, in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights claimed before the court gives its final decision. The condition of urgency is met when the acts susceptible of causing irreparable prejudice can occur at any moment before the court makes a final decision in the case. The Court must therefore consider whether such risk exists at this stage of the proceedings. The Court is not called upon, for the purposes of its decision on the request for indication of provisional measures, to reach a decision on either party's position on the merits, but to determine whether the circumstances require the indication of provisional measures for the protection of the rights found to be plausible. It cannot at this stage make definitive findings of facts, and the right of each party to submit arguments in respect of the merits remains unaffected by the Court's decision on the request for the indication of provisional measures. Having previously determined that Guyana's right to sovereignty over the territory awarded to British Guyana by the 1899 award is plausible, and that there is a link between this right and one of the provisional measures requested, the Court turns next to the question whether irreparable prejudice could be caused to this right and whether there is urgency in the sense that there is a real and imminent risk that irreparable prejudice will be caused to this right before the Court gives its final decision. The Court recalls that the fifth question of the referendum refers explicitly to the creation of the Guyana-Essequibo state, as well as an accelerated and comprehensive plan to be developed for the granting of Venezuelan citizenship and identity cards to the population of that territory, consequently incorporating the Guyana-Essequibo state into the map of Venezuelan territory. The Court further observes that Venezuela's Supreme Tribunal of Justice has confirmed the constitutionality of the questions to be posed in the referendum. The Court notes that Venezuela stated during the oral proceedings that it will not turn its back on what the people decide in the referendum of 3 December 2023. On 24 October 2023, the President of Venezuela, Mr. Nicolás Maduro Moros, publicly stated that the referendum would give Venezuelans, for the first time, the means to take a collective decision as a country. Other official statements suggest that Venezuela is taking steps with a view towards acquiring control over and administering the territory in dispute. For instance, on 6 November 2023, the Minister of Defense of Venezuela, General Vladimir Padrino Lopez, made an appeal to go to combat with reference to the territory in question. Furthermore, Venezuelan military officials announced that Venezuela is taking concrete measures to build an airstrip to serve as, I quote, logistical support point for the integral development of the Essequibo, end of quote. The Court considers that in light of the strong tension that currently characterizes the relations between the parties, the aforementioned circumstances present a serious risk of Venezuela acquiring and exercising control and administration of the territory in dispute in the present case. It therefore concludes that there is a risk of irreparable prejudice to the right claimed by Guyana in the present proceedings that the Court has found plausible. The Court further considers that Venezuela's expressed readiness to take action with regard to the territory in dispute in these proceedings at any moment following the referendum scheduled for 3 December 2023 demonstrates that there is urgency, in the sense that there is a real and imminent risk of irreparable prejudice to Guyana's plausible right before the Court gives its final decision. The Court concludes from all of the aforementioned considerations that the conditions for the indication of provisional measures are met. It is therefore necessary, pending its final decision, for the Court to indicate certain measures in order to protect the plausible right claimed by Guyana as identified by the Court. The Court recalls that it has the power, under its statute, when a request for provisional measures has been made, to indicate measures that are in whole or in part other than those requested. In the present case, having considered the terms of the provisional measures requested by Guyana and the circumstances of the case, the Court finds that the measures to be indicated need not be identical to those requested. The Court observes that the situation that currently prevails in the territory in dispute is that Guyana administers and exercises control over that area. The Court considers that, pending the final decision in the case, Venezuela must refrain from taking any action which would modify that situation. The Court emphasizes that the question of the validity of the 1899 award and the related question of the definitive settlement of the land boundary dispute between Guyana and Venezuela are matters for the court to decide at the merits stage. The court recalls that Guyana has requested it to indicate measures aimed at ensuring the non-aggravation of the dispute with Venezuela. When indicating provisional measures for the purpose of preserving specific rights, the court may also indicate provisional measures with a view to preventing the aggravation or extension of a dispute when it considers that the circumstances so require. In the current case, having considered all the circumstances, in addition to the specific measure that it has decided to take, the court deems it necessary to indicate an additional measure directed at both parties and aimed at ensuring the non-aggravation of the dispute between them. The court recalls that its orders indicating provisional measures under Article 41 of the statute have binding effect and thus create international legal obligations for any party to whom the provisional measures are addressed. I shall now read out the operative part of the order. For these reasons, the court indicates the following provisional measures. 1. Unanimously. Pending a final decision in the case, the Bolivarian Republic of Venezuela shall refrain from taking any action which would modify the situation that currently prevails in the territory in dispute, whereby the Cooperative Republic of Guyana administers and exercises control over that area. 2. Unanimously, both parties shall refrain from any action which might aggravate or extend the dispute before the court or make it more difficult to resolve. I shall now call upon the registrar to read the operative part of the order in French.
Par ces motifs, la Cour indique les mesures conservatoires suivantes. 1.
For these reasons, the Court indicates the following provisional measures unanimously. Pending a final decision in the case, the Bolivarian Republic of Venezuela shall refrain from taking any action which would modify the situation that currently prevails on the territory in dispute, whereby the Cooperative Republic of Guyana administers and exercises control over that area. 2. Unanimously, both parties shall refrain from any action which might aggravate or extend the dispute before the court or make it more difficult to resolve.
Declaration to the order of the court. Judge Robinson appends a separate opinion to the order of the court. Judge Ad hoc Couvreur appends a separate opinion to the order of the court. The text of the order is available from today in typescript. It will be available shortly on the court's website. The printed text will be available in due course. As the court has no further business before it today, I declare the sitting closed.